Hi, my name is Leroy Smith. Welcome to Focus, and my guest is the Attorney General and Minister of Legal Affairs, Anil Nandlall. Minister, welcome to Focus. Welcome to Big Smith News Watch, the studios of Big Smith News Watch.
Thank you, and it's a pleasure to be here.
All right, Minister, the U.S. Human Rights Report blasts the government for the languishing of persons in the prisons across Guyana, and also they cited this due to a slothful judicial process or system. I would like you to speak on this matter.
Okay, thank you very much for inviting me here once again. And the issue that you have raised is indeed a serious one, and it's a very complex issue. And it's not a new problem. We have had institutionally for decades an overcrowded prison system. The government has recognized this issue and has implemented a wide menu of measures to frontally address it. You may recall that we were granted a loan from the IADB, International American Development Bank, dedicated specifically to addressing the concerns of overcrowded prisons. From 2020 to 2025, I took over that project from the previous administration. Not much was done, though the loan was granted and disbursed since 2016. Very little was done from 2016 to 2020. In fact, the loan was about to be cancelled because of non-activity. So I came in and we took over the loan. And since then, using the proceeds of that loan, we have unfolded a multiplicity of measures, all directed at addressing the issue of overcrowding in the prison system. So where do I start? Let me deal with legislation first. You have identified in your opening remarks a slothful judiciary as one of the reasons for the overcrowded prisons, and that is correct. So one of the focuses of the program was to address sloth in the judiciary. So what causes an overcrowded prison? Because a lot of people are on remand, and they are on remand because their cases are not being disposed of effectively. So we examine the judiciary itself, the legal process, to determine how we can address this output of the system. And something that jumped out at you, was the sloth in preliminary inquiries. And that is recognized throughout the Caribbean and the wider Commonwealth. And countries have moved to abolish PI. We have gone in that direction. And we have amended our laws. In fact, we have passed a new act. A legislation is now in place abolishing PIs, preliminary inquiries, and we now do paper committals. So a preliminary inquiry would last about 3 or 4 years. And then the accused either is discharged or is committed to stand trial before a judge or jury. Invariably, the charge is murder, and you don't get bail for murder. So the man is in prison or the woman is in prison for 3 to 4 years just to wait for the trial. If we are able to dispense with that process or accelerate it, obviously you're taking out 3 to 4 years of languishing in a prison waiting for trial. And that is what the abolition of the PI does. And is replaced with a system that allows for statements to be taken, the statements to be presented to a magistrate, The magistrate is to read the statement, hear the accused persons through his lawyers, and hear the prosecution, and then determine, based upon the statements in the file, whether a prima facie case is made out for the accused to stand trial. That entire process will take only a few months, maximum. So that's one measure. Another measure is pre-bargaining, getting the accused and the prosecution to sit at a table and work out a sentence or a plea deal that obviate the need for a trial. So you get charged today, you can strike a plea deal immediately and you finish. If it is that you take a term of imprisonment, it will obviously be a reduced term based upon the gravity of the offense, the type of the offense. An appropriate sentence will be determined. You go, you serve that sentence, and you come out back. So you cut out years in the system. Another measure that we implemented was the enactment of a bail act. One of the reasons why people are in jail and languishing for a long time is because of inconsistent exercise of discretion. And without a bail act, that was prevalent. So one magistrate would remand and remand for 3 months or a long period, and another one would grant bail on similar facts. That inconsistency offends the public and it brings a lack of uniformity to the system. It also permits persons to stay in prison for undue period of time. You also have to balance that against the population that wants to see penal sanctions imposed. Most of the time you're a journalist and you will see the public outrage expressed when persons are granted bail. So you have to balance that public expectation. But the law is that once you are satisfied that the man will not flee and will turn up for his trial, you ought really to grant bail because the Constitution says that he must get bail because he's presumed to be innocent.
I'm glad that you raised that
Right.
point. We had a situation last month in Boyabis, and I don't know if you were aware as the Attorney General, but are you aware that there was a 61-year-old gentleman that was remanded to prison for 25 days in the New Amsterdam prison for the damage of a padlock that cost $1,500?
No, I'm not aware of that.
In a
But
situation like that, there's a damage to a padlock, a $1,500 padlock. You send somebody to jail for 2.5 weeks when you could have simply, like,
yeah, I
I don't
understand.
understand.
So that it's because of those inconsistent and what appears to be an irrational exercise of a discretion, we have enacted the Bail Act that sets out clearly what are the principles that must be taken into account by a court when granting or refusing bail. And they are listed, and then it tells you what offenses are bailable and what offenses are not bailable. And it also deals with how you can challenge a decision where bail is granted or bail is refused. So both sides have a right of challenge. So it was never put in a law before. So now it is there. So there's another measure. We have a whole host of other different pieces of legislation which we implemented, all designed to bring greater speed to the administration of justice.
When could
But outside of legislation, so I've given you a few legislation, but there are other measures that we put in place. We established a law reform commission
yeah.
to constantly review the law, take complaints and policy recommendations from members of the public and important stakeholder organizations and make recommendations for legislation. So that's there, permanently there. And as always, reviewing the situation. Then we did sentencing guidelines. Another issue that we have is lack of uniformity in sentencing. One judge would give 60 years, another judge 20 years for the same offense, similar aggravating factors or similar extenuating factors. But you see, the sentences are vastly different. We have put sentencing guidelines in place that ought to guide the judiciary. Then, of course, we have increased the complement of judges, as you know. We
No,
have
before you go there, Minister, what and whether by law or policy, what is the required amount of judges we need to have at this point, and what is the required amount of magistrates that we need to be having at this point, and how far are we from those numbers, if far at all?
Okay, so let's start with the Court of Appeal. We used to have, I think, 5 judges at the Court of Appeal. And invariably, we never had a full complement. For the longest while, we have had 3 judges in the Court of Appeal. We amended the Court of Appeal Act and increased the complement to 11 judges now. No, 13 judges in the Court of Appeal, I think. Okay. Right? So you can have several courts of appeals sitting at the same time. I am hoping that we will have several sitting in the 3 counties at the same time. So a court of appeal can go to, a court of appeal is normally 3 judges together.
Okay.
So one can go to Essequibo, so you have enough, and hear all the cases in Essequibo, at periodic intervals. Another court of appeal can go to Berbice, another 3, because you have a lot now. And then 3 can be in Georgetown. So you can have easily 3 courts of appeal sitting in the 3 counties of the country, dealing with appeals only. And that amendment we did over the last few years. Then we have the High Court. The High Court.
But before you go there, what is preventing the dispensation that you just spoke of, 333? What's preventing us?
The judiciary is an independent.
There?
No, the judiciary is an independent institution. The judiciary runs its own business.
Yeah, I'm aware.
It directs its own affairs. The government's duty is to fund it and resource it. And the judiciary will tell you that they have never been as resourced now. They have never been the beneficiary of such vast amount of resources than they are benefiting from now. The High Court, in terms of complement, when I was Attorney General the last occasion, we had increased it from 12 to 20. It is 20 now. And I think almost all the vacancies have been filled. The magistrate, I can't remember, I believe it's somewhere about 15.
The requirement or the present amount?
The requirement. There were some changes made recently. I can't remember what the numbers are now, but we appointed a number of magistrates recently, about 12 over the last 5 years. Then we have a court called the Land Court. We appointed about 4 Land Court judges recently. So a lot of progress have been made in human resources in terms of ensuring that the judiciary has the sufficient judicial officers to bring speed to the system. We've invested a lot of money in e-litigation, and we now have software programs that we bought at great costs. And the system there's now an e-litigation system. We have an automatic recording, audio and video recording system in almost every court in the country. That brings great speed to the disposal of cases. Before that, every word had to have been written down in longhand by the judicial officer or the magistrate. The thing is now recorded automatically, and you get the transcript just after that. All these are systems that we have put in place to ensure that there is great speed in the judicial system, and it is bearing fruit. The system has increased, the system has improved significantly. The efficiency, the dispatch, the, the, um, the organizational manner in which the judiciary is functioning now is far better than it ever was, in my respectful view. But of course, there is still a lot more work to be done. At the prison end, you know that we have been doing massive prison reforms. We are building over a prison at Lusignan.
Yeah.
We have done great expansion at Mazaruni and at New Amsterdam. And these are work in progress. A brand new, I think, several million US dollar modern penitentiary system is being established at Lusignan with all kinds of facilities, educational facilities, training facilities, medical facilities, of course. The experts in this area they have argued, and I believe successfully so, that punishment must be more rehabilitative than punitive. And that's the direction in which the prison system is going. Under the same IADB funded project, we have redrafted the prison rules. So we have a modern prison rules that have been redrafted and that will go with the new prisons once it is established. So substantial progress have been made at least over the past 5 years alone
So those
in
are
relation to addressing the prison population. One last thing before you go. We also have a piece of legislation that condenses and put in one place all the alternative sentencing measures that are available in the law. You know, there are many non-custodial sentences that can be imposed.
yes.
So that relieves the prison system of the load. So you have community service, you have a whole host of them, right? We have a bill that will be taken to the parliament as soon as it resumes to deal with that. We also have an evidence bill. This is a massive undertaking, a brand new evidence act that is intended to modernize the evidential procedural structure within the legal process of the country. Our Evidence Act is the 1893 Evidence Act of the United Kingdom. You hear what I'm telling you? 1893. So it's 100 and how many years old? Nearly 200 years old. And that's what we are using. Obviously, that can't operate in today's society. A modern one has been drafted. I have it. And as soon as, we go back, this consultation will have to begin because we have to consult widely on this matter.
So those are the very big apples. Let's talk about the small things. The remanding of persons for these very simple offenses, like very small offenses. We still see it happening a lot, like the padlock that I spoke about
Yeah.
and so on.
So that has to do with the judicial officers who are exercising these powers. As an executive member of the government or as a member of the executive government, I can't direct a magistrate. I could barely criticize the magistrate.
Yeah, but it's not about directing. It's about putting the systems in place at the policy level
But how?
to ensure conformity
But
and the laws.
we have
The laws.
we have put the law in place. But it's a matter now of applying the law.
Good. So
in a
if
satisfactory
these
manner.
magistrates and these judges are not applying, then we move to the other issue of are the systems that are in place to ensure that they're dealt with for non-compliance and so on Are
So,
those systems working?
so they are working, but there is always room for improvement. So the judiciary itself, when you read its policy orientation and you read its goals and objectives, and in any judicial system, the judiciary is committed and must be committed to accountability. Accountability includes its behavior, it's the way it conducts its affairs, the way it interprets law, the way it applies law. And if if they are not applying the law properly, well, there's an appellate process that allows every litigant to challenge the decisions, and they go all the way to the CCJ. So that's one process that makes the system accountable. But outside of that, when there is such conduct that goes beyond the pale of a wrong discretion and amounts to misbehavior, then you have remedies that are available. But in our society, and in society like ours, you hardly find persons who would want to lodge a complaint against a judge or a magistrate for fear of repercussions. And it's not something that we have done in the past. You, as a member of public, you can lodge a complaint with the Judicial Service Commission that you feel that this judge, that the decision of this judge is not merely wrong, but this must amount to an abdication of responsibility. It is so wrong that no rational judge would make a mistake like that, or no rational magistrate, no reasonable magistrate can make a decision like this.
Given the systems that are in place for alternative sentencing and so on, do you believe that the judicial system is adequately utilizing them?
Well, in all fairness, this bill that I'm speaking about is not yet law, right? But there are
But
many
there are already
measures
mechanisms in
in
place that they
place
could
right
use.
now that
That's what I'm
I,
talking about.
I, I believe are not being utilized in the manner that they should be utilized. But it also got to do with a bar too, you know. You have to have a vibrant bar and a bar that reads. And sometimes I get the impression that our lawyers are not reading. We are passing a lot of laws, and I don't believe that these laws are being used. I the lawyers don't even get they don't even get copies of it, and that is a worrying thing. So we have to you have to get the lawyers and put them to sit down here and let them tell you whether they even know what are the alternative to custodial sentences that exist in the legal repertoire of Guyana. I'm telling you that many of them who are practicing criminal law will not be able to answer that question. So you got to bring them too. We got to improve the system. Got to improve from every perspective,
Holistically.
right?
We are still on the issue of the um, number of persons languishing in prisons. If you've just joined us, this is Focus. My guest is the Attorney General, Anil Nandlall. There is a system in place for parole and so on for persons in prison. We haven't had any paroles done in the last 3 years. What is hampering this? Why isn't this happening? If we're trying to address the issue of an overpopulated prison system, also.
Um, I am not sure that persons have not benefited recently
In the last 3 years,
from parole. They
they've
have
not
not.
been any
I'm
parole.
not sure. But we have a parole board.
Hmm.
I know that the chairman, there were some vacancies and they were filled recently because I had to make submissions to the Minister of Home Affairs as he's the subject minister for the parole board. But I'm not sure why it's not functioning in the manner that it should. But the system, parole is part of our system, and it can address the issue of overcrowding. But you see, um, Leroy, the issue also is, as I said in my beginning remarks, You have a population that is very weary of crime and criminality. They are largely law abiding citizens and they hold the view that criminals or those who are found guilty should receive the highest form of punishment. We have a society that demands that. And that is not only true of Guyana, that's true of the entire Caribbean. So you want the parole board to function, but if the parole board is to put many people on parole, you will have a public outcry that we are releasing prisoners.
Not if the
Right.
not I don't think you'll have that outcry if the guidelines are followed in ensuring that it's executed, but also I think what is lacking heavily and tremendously is the issue of sensitization. If persons understand the role of the parole board, understand why there is this law in place, understand. So it's all about understanding. And in order for you to understand, there has to be public relations, a heavy public relations drive in every area, every aspect. And I believe that is extremely lacking. And that is why you'll have the reaction that you mentioned in here.
An important measure that we put in place also over the last um, 5 years is to remove custodial sentence on small quantities of marijuana. If you were found with marijuana, you had to go to jail for 3 to 5 years. We have now removed custodial sentences up to a particular quantity, right? But it's still illegal, but you don't have to go to jail for that, right? So that had freed up the system tremendously and put a lot of people out and allows a lot of people to stay out while they smoke marijuana.
Um, our system at the prisons, it's nine, let me check my notes. Our prison act was established in 1957.
Yeah.
What is on the charts to ensure that it is fixed in keeping with the current correctional
Right.
standards?
So that's what I'm saying. We have a draft prison act or a draft prison bill, big like this. In fact, it's on my desk, right? That's completed. We gotta go through one more round of consultation to ensure that the people, the technical people, are comfortable with it, and then it's for cabinet's approval. But that's a comprehensive, new, modern legislation that takes into account all the recent developments that have taken place in prisons and prison reforms. It shifts the emphasis away from punitive to rehabilitative and reformative. It mandates improvement and rehabilitation programs, and it's a good bill. And we have accompanying regulations to go with it. I should also tell you that under the same program that I'm speaking about, we trained over 150 something prison officers. We paid the University of Guyana to train um, over 100 and something prison officers and certify them in the area of how to handle, their job in the prisons and taking into account the modern developments that have taken place. We also paid the University of Guyana to do a very unique program, which I'm very proud of, called the Special Prosecutors Program, whereby I was able to bring together all the persons who had completed their Bachelor of Laws degree at the University of Guyana, but were unable to go on to one of the law schools for whatever reason. And we had nearly 100 of them. We brought them together and we trained them. And they are now prosecuting in the magistrate's court alongside police officers. So no other country has this. So you have more than you have an LLB graduate instead of a policeman prosecuting in the courts of our country. So that obviously will bring a greater quality of service to the prosecutorial system. And we have had some problems, but I'm working assiduously to iron out those problems. So, but that's another measure that we brought in under this IDB project.
All right, Minister, just before you leave, there is a general view, and this is my our final issue. There is a general view that SOCO, the Special Organized Crime Unit, um, it has a lot of powers under the Constitution and so on, but there is a view that SOCO's powers are unchecked, and because it is unchecked, elements within SOCO seems to be using SOCO as a weapon against individuals and persons working at SOCO might have a personal issue with. And I say this because I have um, information. In fact, it was brought to my attention that a police officer, a young police officer, carried out a an operation, and because the operation was carried out on someone affiliated with SOCO, that police officer was called in, and an allegation was put to that police officer, and she had to give a statement and so on, and then that statement is sitting there, and it comes over as a form of intimidation, and so that's why I said SOCO power seems to be unchecked, and
No,
what is
no.
being done?
SOCO is part of the Guyana Police Force. None,
Semi-autonomous almost.
yeah, it is semi-autonomous by law, but it's still part of the Guyana Police Force. It comes under the superintendence of the Commissioner of Police. And like every part of the Guyana Police Force, SOCO is bound by the Police Act and by the Anti-Money Laundering, Countering the Financing of Terrorism legislation. If there is any abuse or misbehavior on the part of SOCO, it will be dealt with in accordance with law. People sue SOCO in the same way that they sue the Guyana Police Force on a regular basis. Um, because of my connect, because I'm the subject minister for the AML CFT sector, I exercise some sort of supervisory jurisdiction, for want of a better word, over SOCO. And I don't have any great number of complaints about misbehavior at SOCO or abuse of powers. I appear for SOCO in many, many matters, as I do for the police force. And I don't see SOCO being um, a recalcitrant organization in any form or fashion. Of course, allegations are being made, and allegations are being made right across the public sector. I don't think SOCO can be singled out.
What are some of the
Um,
allegations that you
well,
usually
I
get?
was going to give you some.
Okay.
Like you had one with um, a lawyer being mistreated, and I offered I offered an apology to the lawyer publicly, and I offered compensation to the lawyer. The lawyer rejected all of that, went to court, where, caused big protest action, got lawyers to write the Caribbean Bar Association and so on, sensationalizing the matter. And we went to court. And you know what the court ordered? Less than $1 million in compensation. I
And
was offering the lawyer more.
how much
And
more?
much more than that. Much more than that. And what was the allegation? The young lady, the lawyer, her cell phone was taken and she was asked to remain in a room, an office. And she claimed that that was false imprisonment and so on. But I, I was concerned as head of the bar because lawyers must be allowed to interface and engage their clients in a professional manner when they are in police custody. So that was, I don't. I represent Soku in many civil cases in the court, and we have won many of these cases.
But internally, like in that matter with the lawyer, what was done internally, in terms of, were there any disciplinary action taken against those that?
The officer, I can't recall, but I know that he's no longer a member of Soku.
Mhm. Is this
Right?
by retirement or
No,
a
no,
decision was taken?
he was transferred out, and he is somewhere. I saw him the other day, in some other place. He's not at Soku though.
All right, Minister, I don't want to dwell on Soku too much. So one final question. Calvin Brutus, Assistant Commissioner of Police. Um, there was a whole lot of fanfare in relation to his matter and so on. And we have all of this evidence. We have all of that evidence. But the matter seems not to be heading to the stage of trial. Soku, because I've been covering these matters, and the matters have been receiving wide media coverage. But Soku never seems to be ready to go ahead.
No, no,
What is happening here?
you have a particular bias.
No, I don't have a
Yeah,
particular
man, I
bias. No,
know.
I would not call it a bias.
I have looked at your coverage. You defend Mr. Brutus.
No, no, no.
Brutus is charged.
We cover the matter
My friend,
because
no,
we
I know
have
what
the facts of the matter.
All right. Well, we have the.
And do you believe the government was
Soku has the
misled in
facts.
relation
I
to?
I don't know, not at all.
Okay.
Monies are missing. The monies are missing, and that's a fact. And there's evidence connecting the money to the money were in the man's account anyhow. I don't want to get involved in that. But the case, you would recall that his wife was permitted to leave the country. I am on public record criticizing that decision. I know that repeated representations had to have been made in the court for her to return. I believe she finally returned. She violated the magistrate's decision that permitted her to leave because she didn't come back within the time stipulated. But the magistrate keep granting an adjournment and an extension of time, and that may have led to a delay. But based upon the information, the limited information I have, there is preponderance of evidence in that matter, and the matter will be proceeded with as far as I'm concerned. It should be proceeded with because it involves the embezzlement of nearly $1 billion of public monies.
But one of the things I don't see being spoken about is the chain of the events. It is not. Nobody seems to be addressing it. If I
Which chain of which event?
The chain of events that caused the alleged
No, man,
amount of funds into
Leroy,
that account
we cannot
minister.
discuss. You can't discuss the matter here. We have spoken enough on the matter. Let's let the court determine the matter, and that's where we should. We're not going to get involved in that now. It's
Thank you
improper.
Good. Thank you very much. You were looking at Focus. My guest was the Attorney General and Minister of Legal Affairs, Minister Anil Nandlall. Thank you very much, and we'll see you here again.
Thank you.